Pena i hena rai, tēnā koe.
Tēnā koe, Mr. Speaker. Thank you for this opportunity. I rise for the Labour Party in support of the Evidence Amendment Bill, sir. And I do want to actually extend on some of the comments already made across the House. Firstly, to congratulate the Justice and Electoral Select Committee because just like Mr. Bishop, it was one of my first pieces of or proposed bills before the Select Committee that I was able to get my teeth stuck into. Certainly learnt a heck of a lot from members across the House, and robust debate was had right through the Select Committee and of course in this House. And we've come now to what is a good bill, a bill that will pass through this House. But I take the point by Mr. Kennedy Graham and of course others in the House who have said it's a step in the right direction. Sadly, we feel it could have done a little bit more. And I'm reminded of the words of Sir James Henare, who said, we've come too far not to go further. And this is one of those opportunities where perhaps we could have done just that little bit more to ensure that the trust, the faith and the integrity of the system is sound and strong. We know in recent weeks it's come under question, it's come under fire. We know that it's important in society that when those who are processed through the justice system, or those who have had to appear in front of the court to give evidence and other matters, we want to make sure that they enter into a system that is fair, a system that carries strong integrity in the eyes of the New Zealand public. And I think that this particular bill, sir, goes a long way to doing that. It keeps in step with some of the technological changes that too often this House is too slow to realise. And I think that's a good thing. I also want to comment about the ability for children to give evidence in a way that will protect them, in a way that will ensure that the re-victimisation doesn't occur, and that tamariki, who have important things to say in matters in front of the court, are actually heard and are looked after. I also note that the judge, in the bill, the judge also allows for support people to be there for those tamariki, whether one or several. And that discretion is left up to the judge, but I think that's an important step. To leave a child in the arms, or in the care, of officials or lawyers on such a heavy issue, on an issue that will no doubt have severe consequences, not just for the child, but for the entire case. And I think it's an important step forward to make sure that those tamariki, those children, receive the kind of support that they deserve when they enter into this particular system, the justice system. Mr. Speaker, it is good lawmaking. It makes sure that the evidence that is provided is robust. The members across the House have already spoken about many parts of the bill, but I just want to finish my contribution, given it's a short one, Mr. Speaker, about that opportunity to do just that little bit more. It's been mentioned about the age, it's been mentioned about the SOPs from the Green Party and across the House, and this is one of those opportunities where I take the words of Mr. Bishop, who said, look, perhaps we'll end up finding ourselves back here to do just a little bit more. And that's a bit of a shame, given that opportunity presented itself in this term of government. And we hope then that in the future we will come back here, we will be able to make this more robust, to make sure that the integrity and the way in which the New Zealand public views the justice system is in good stead and is in good vein. Kia ora, Mr. Speaker.